for their input there. So the main thing is to hear from our guest speakers. So without too much further ado, I'll hand over to Dr. John Chesima, who's the Director of Strategy from the Office of the Public Advocate in Victoria, and he's going to speak to us on mental health reform challenges, perspectives from Victoria. So I'd like to get you to welcome John. Thank you.
Thanks very much, Karen. I might say my first word might be to the panel members, because I'm going to be showing some slides. I don't know if you maybe want to. You don't really have to look at the slides, but it's on the slides, so you might find them just looking over your heads. My first act as a visitor is to kick the panel members off the stage.
That's right, that's right.
Thanks, Karen, for that introduction, and I just want to begin by acknowledging the traditional owners of the land on which we meet, Turrbal peoples, and I pay my respect to the elders past and present. I also want to acknowledge the expertise that exists in the room here today. I know there's considerable expertise, certainly amongst the panel members and people in the room, some of whom I met just in the minutes before today's presentation began. So I do acknowledge there is expertise in the room. I look forward to your questions and comments later on. Thanks very much to ADAA for hosting this event, bringing me up here. Particularly, I want to thank Jeff and Karen and Jess and all the team for the work they've done in putting today on. I want to provoke people's thinking in today's talk. It's Mental Health Week, and I want to raise some big issues. So the subtitle of this talk is Perspectives from Victoria. I want to make it clear at the outset that some of these perspectives are from elsewhere as well, including international perspectives. And I'd also want to make clear that Victoria as a state doesn't entirely embrace as yet some of the ideas I'll be discussing. So it'd be wrong for me to say, you know, that I'm speaking on behalf of Victoria or the Victorian government. I'm giving you some reform perspectives from the Office of the Public Advocate in Victoria. Some of the reform ideas I'll be discussing are contentious. What's not contentious, at least at an abstract level, is the principle that underwrites the reform ideas that I'll be talking about, that people should have the key role in determining the treatments that they receive. What is contentious is how that principle is balanced with the imperative to keep people and members of the general community safe. So it's in undertaking that balancing act, which mental health legislation seeks to do, that the contentions become more manifest. So one intervention can be labelled by one person as a therapeutic response to help a person over an acute crisis that may endanger their own or someone else's safety. Another person might call that same intervention psychiatric torture or a breach of human rights. You're all familiar with this debate, I know. Just wanted to background today's talk. So when should we prioritise protection, even if it means limiting other freedoms? And when should we not, even if that means risks are taken? Mental health legislation always pitches itself somewhere on that autonomy protection continuum, as indeed does guardianship legislation. I'm going to suggest to you some ways in which that current calibration might be rethought, and I'm also going to make some far more mundane observations in this presentation. So, onwards. Right, a quick word about the Office of Public Advocate, who we are. Now, you're unusual in Queensland in that you've got a public advocate and a public guardian. They're both sitting next to each other. In Victoria, we've only got one. We just have an Office of Public Advocate, which is the adult guardian of last resort, as well as being a systemic advocate. So we've got Offices of Public Advocate in South Australia, Western Australia, Victoria, and here standalone. In the other, and in the ACT, in the other jurisdictions, we've got a public guardian. Right, so we are the guardian of last resort in Victoria. 31% of our guardianship clients have mental health as their primary disability. Interestingly, this is something about the guardianship jurisdiction. The biggest disability grouping of people guardianship are people with dementia. That was never anticipated to be the case in the 1980s when the modern guardianship system was set up. We investigate applications to our guardianship tribunal. Unusually for an independent statutory authority, we have a large number of volunteers who volunteer their services in 4 of our volunteer programs. We've got 800 volunteers, which is quite unusual. We've got our community visitors program. That's a volunteer scheme in Victoria. It's a different scheme up here. We have an independent third person program where volunteers sit in on police interviews where someone's being interviewed has an apparent cognitive disability. We have community guardians and corrections independent support officers, people who assist with the hearing of disciplinary procedures in prisons. We advocate individually and on a systemic basis. We have an advice service and we deliver community education. That's who we are. Our community visitors, one of the strengths of our community visitors program is that we provide an annual report to Parliament. So our community visitors are appointed by the Governing Council. They visit mental health facilities. We have 3 streams, one in the mental health stream, one in disabilities and one in supported residential services, kind of boarding houses. In our mental health stream, our community visitors conduct just under 1,500 visits every year to over 140 different units in the state. Our community visitors provide an annual report to Parliament, which usually gets some press because our community visitors make observations at a statewide level about reforms that they think are needed. All right, the background to today's talk really has to be human rights. So let me just give you a couple of slides that tell us where we're at in terms of mental health and human rights. Victoria is the only state so far, just getting updated about where Queensland is with your Bill of Rights. We're the only state with a Bill of Rights. ACT also has one. Crucially also in this area is the Convention on the Rights of Persons with Disabilities. And really there are 3 key themes in that international convention, which Australia's signed and ratified. One of those is that we need to minimise state-directed substitute decision-making. We've got another slide about that in a second. Another is that supported decisions need to be preferred. And a third theme is the prevention of abuse. Now, what I'll show you here is what you might call one extreme view about the implications of the Convention on the Rights of Persons with Disabilities for substitute decision-making regimes, in particular for today's talk, mental health regimes that enable compulsory detention and treatment. So this is a comment from the UN Treaty Monitoring Committee, the Committee on the Rights of Persons with Disabilities. So I've got 2 paragraphs that I just want to read to you. One is that state parties, such as Australia, their obligation to replace substitute decision-making regimes by supported decision-making requires both the abolition of substitute decision-making regimes and the development of supported decision-making alternatives. The development of supported decision-making systems in parallel with the maintenance of substitute decision-making regimes is not sufficient to comply with Article 12 of the Convention. And then even more specifically on mental health legislation, recognition of legal capacity is inextricably linked to the enjoyment of many other human rights provided for in the Convention on the Rights of Persons with Disabilities, including, but not limited to, the right to be free from voluntary detention in a mental health facility and not to be forced to undergo mental health treatment. Now, I hasten to add Australia doesn't agree with this view, and indeed when it adopted the Convention, made what it called a declaratory statement saying it didn't consider that this would be the interpretation that would hold, and it wasn't signing on the understanding, it was signing an understanding that this wouldn't hold, this kind of view. But I want to show you that view because that is a view that has been put out by the Treaty Monitoring Committee, and it's important for us to be aware of it and to engage it. All right, so you can see there are a range of different ways in which substituted decision-making is possible here in Australia. Through the work of guardians appointed by your QCAT up here, through the operation of attorneys and others appointed under enduring powers of attorney when those instruments become active, through the operation of statutory health decision makers, which every jurisdiction has. So if you're unable to make a medical treatment decision, every jurisdiction has an automatic hierarchy which allocates responsibility to someone, and they make decisions on your behalf. Also, of course, includes compulsory mental health treatment. It even includes NDIS plan nominees. I'll come back to the NDIS later on. So there are a variety of ways in which substitute decision making is possible in Australia. Okay, there are a number of problems with substitute decision making. First of which is the ongoing debate about the consistency of such arrangements with human rights developments. Kind of more pragmatic concern about substitute decision making. It can be a blunt response to service failure, neglect or harm. I'll just give you a kind of caricature of this bit. I'll give you an example from elder abuse. So someone might have a significant cognitive impairment. They might be ripped off by their eldest adult child, eldest adult children who are most likely to be responsible for elder abuse. They might be financially swindled by their eldest child. One of our responses might be to make a financial management or administration order removing that person's decision-making authority. And so that could be a blunt response. An alternative response might be adequate policing of the crime to which the person's been subject. I'll just turn the slides off and on again. There's also legal complexity. One area that's occupying Natalie and myself, Mary, a number of others, is the interaction between NDIS federal laws and state territory laws. We know that professionals don't know the substitute decision-making laws. Doctors, Ben White and Linda Wilmot here at QUT have done some excellent research proving that. In Queensland, New South Wales and Victoria, the doctors don't know the law. Uncertainty about when substitute decision-making might be required. For instance, admission to aged care, something the Australian Law Reform Commission is engaged in its elder abuse report. Of course, with substitute decision-making, that requires the assessment of capacity. That's a fraught topic sometimes. We also have the question of how do we monitor substitute decision-makers. It's an enormous power to have over somebody, the power to be able to make decisions for that person. Okay, so the point I want to make now is that we are gradually moving in Australia. I'll give you some examples from national examples, but also state examples from Victoria, about the ways in which we're gradually moving towards recognising supported decision making. So the view with supported decision making is that it's a broad concept that points to our need to enable people to be supported to make their own decisions, rather than have other people make decisions for that person. The Australian Law Reform Commission, in its 2014 report on equality, capacity, disability and Commonwealth laws, recommended reform of Commonwealth, state and territory laws and legal frameworks to ensure that supported decision making is encouraged. Representative decision makers, substitute decision makers, are appointed only as a last resort, and even if they are appointed, a substituted judgment approach applies. So the will, preference and rights of the person directs decisions. So I'm saying substitute judgment. So that's as opposed to a representative decision maker using what they think, making a decision that they think is in the best interests of the person. The Australian Law Reform Commission is saying if you have a substitute decision maker, they should be required to make a decision that the person would have made themselves, not something that the substitute decision maker thinks is in the best interest. That's a significant change. So on the topic of mental health, the Australian Law Reform Commission said state and territory governments should review mental health legislation with a view to reform that's consistent with those above points. This might involve, for example, moving towards supportive decision-making models. I've put some ellipses and dot points after that. They then refer to the situation in Victoria, which I don't think is kind of the best example, so I'll cut that out. But nonetheless, the point I want to make is the Australian Law Reform Commission is encouraging a move towards supportive decision-making. Okay, so I'll show you very quickly a number of ways in which this is starting to gain some recognition. Victoria's Mental Health Act, we'll talk more about Victoria's Act in a minute. There are some phrases in the mental health legislation that talk about people being supported to make or participate in decisions. And there are two new ways in which people can have a greater say over the decisions that affect them through their appointment of nominated persons and their use of advanced statements. I'll say more about those two possibilities in a moment. We've had new powers of attorney legislation that enable the creation of or the appointment of a new category of decision-making assistant, a supportive attorney. Supportive attorneys have the power to collect information, communicate information, but they don't make the decision. They can support a person to make a decision. There was a proposal to reform the guardianship legislation in Victoria that wasn't passed, that had a similar category of decision-making assistant, a supportive guardian, that didn't get passed. In the NDIS, there are some clear nods to supported decision-making in the general principles. Behind the legislation, people with disability should be supported to participate. They should be supported to exercise choice. People should be involved in decision-making processes. In Victoria, more recently, we've got new medical treatment legislation that comes into force in March next year that enables a new category of decision-making assistant, a support person. It's very similar to a supportive attorney. They can get information and communicate information. They can assist someone to make decisions. They don't make the decisions themselves. Of course, when it comes to supported decision-making, you can do a lot without legislation. You don't need legislative categories and legislative instruments in order to enable supported decision-making to occur. We've been involved with two supported decision-making projects, very small projects, that have matched volunteers with people, and the idea has been that those volunteers would assist the individuals with cognitive disability to make their own decisions. They've been very small scale. I won't go into those in any detail, but the point is the practice of supported decision-making can happen without any legislative reform. I still think legislative reform, though, as a way of signalling to the community that this is important. One project I thought you should be aware of, if you're not already, I know some people will be, but this is some research led by Professor Rakonovich at Monash University, also including Benedict McSherry at Melbourne University. There's a whole website devoted to supporting decision-making in the mental health space. So I do encourage you, if you're not familiar with that website, to have a look. There's videos and everything. It's a very useful website. And I'm happy for these slides to be made available. That's the web address there down the bottom. Okay. So, substitute decision-making laws, we know, seek to protect a person by enabling someone else to make decisions for that person. But in doing that, they inhibit other freedoms. The broad challenge in the law reform process is, of course, what's the right balance between autonomy and protection? That's really the question of background today's talk. So there is a general trend now towards seeing a limit to state-appointed substitute decision-making, the encouragement of supported decision-making, and the improvement of protection mechanisms. So I'm going to be focusing, of course, on the Mental Health Act in Victoria, but I do want you to know that's one reform that has to be seen with a suite of other reforms that are generally moving in that same trajectory towards greater involvement of people in the decisions that affect them, which has received a question about our powers of attorney legislation in 2014, our medical treatment legislation of last year that's yet to come into force. It also underwrote reforms that have been recommended to our guardianship legislation that hasn't as yet been enacted in large part, and we're still hopeful will be. All right, so when it comes to our Mental Health Act, these are the key provisions that I'll just take you through. So the scheme for compulsory treatment in Victoria is, in order for a person to be detained, they must have an appearance of mental illness. That will only permit detention for 72 hours. Afterwards, you must have an inpatient treatment order made, which is temporary up to 28 days, which can be extended by 6 months by the Mental Health Tribunal. The Mental Health Tribunal made 2,500 orders on inpatient treatment orders in 2016 and 17. Likewise, community treatment orders can be made temporary up to 28 days by the authorised psychiatrist, but then can be extended by 12 months. months by the Mental Health Tribunal, and we had 3,400 of those orders in 2016-17, the year to 1st of July this year, made by our Mental Health Tribunal. In Victoria, there has been an attempt to increase the ability of people to consent to treatment by detention. But what happens if they refuse? So this is a peculiar section that doesn't apply here in Queensland. I just want to briefly show it to you because it highlights some of the kind of contradictions at play when it comes to mental health legislation. So the treatment criteria in Victoria are that the person has a mental illness, and because the person has a mental illness, the person needs immediate treatment to prevent serious deterioration in their mental or physical health or serious harm to the person or another person. And the immediate treatment will be provided. And there's no less restrictive means reasonably available. Now, in Victoria, this sounds odd, and I don't want to be flippant about it, but a person can say yes but not no. So why do I say that? And this does rile some mental health applicants. So this section applies if, I'll just take you through the nuts and bolts of the law. If a patient does not have the capacity to give informed consent, or if they have the capacity to give informed consent but don't give informed consent, the authorised psychiatrist may make a treatment decision. So quite literally a person can say yes, but if they say no, they can be overridden. Now there is a therapeutic, as I say, I don't want to be flippant. I have raised this with authorised psychiatrists, and they say, I understand that's a legal take on this. There is a therapeutic intent in that we can work with the person, so it would be far better if you're in a position to be able to consent to this system than if I just simply override you. So they do craft that as a therapeutic arrangement. Nonetheless, I think that it still does hold that you can say yes but not no in Victoria. It's different here because incapacity to consent to treatment is one of the criteria for involuntary detention treatment. All right, some of the ways in which Victorian legislation has moved to enable people to have a greater say over their own treatment includes the use of nominated persons, so that person can receive information that otherwise privacy laws would restrict, and people can make advanced statements. Now, I'll show you the legislation around advanced statements in a second, but they can be overridden. The uptake of these two possibilities is low, I have to tell you. It's one recent report, about 2% of people that are known to registered users of psychiatric services have availed themselves of either of these. So it's a low taker. There are new review mechanisms in Victoria. The Mental Health Tribunal replaced the board. We've got a Mental Health Complaints Commissioner who received the year just gone by, the financial year just gone by, she received 1,700 new inquiries and complaints, and they point to a high success rate of complaints being resolved one way or another. There's also the option of second psychiatric opinions. Now, when I mentioned advanced statements, the law around advanced statements is that the main part is Section 73. An authorised psychiatrist can make a treatment decision for a patient that's not in accordance with the advanced statement if the authorised psychiatrist is satisfied that the treatment is not clinically appropriate or is not a treatment or ordinarily provided by the business. So that's a pretty low threshold for overriding someone's statement. Now, we suggested to you later on there's real scope there for elevating the legal standing of advanced statements. All right, when it comes to electroconvulsive treatment, which is, of course, a contentious category of treatment, in Victoria the situation is quite uncertain in some ways. There's uncertainty around the ability of substitute decision makers to make decisions for non-compulsory mental health patients. Now, the reason for this is complex, but there is a bit of a kind of legal standoff here as to whether, so if you're a compulsory patient who's subject to the Mental Health Act, and ECT can be provided under that legislation. If you're not a compulsory patient and you don't have capacity to make your own treatment decisions, can your substitute decision maker make that treatment decision in relation to ECT for you? And it is unclear in Victoria. There are legal views either way. It'll change in March next year, the situation will be clarified when our new medical treatment legislation comes into play. So the last point, I guess, is really the key one. From 12th of March next year, there'll be a new requirement in Victoria that all ECT treatments for adults who are unable to consent to it must receive mental health tribunal authorisation of their patients or not. So that's what's being clarified in Victoria. Right, ECT was used in Victoria in public mental health facilities more than 12,000 occasions last year. Mental Health Tribunal made 588 orders in the year just gone by, the financial year just gone by, authorising ECT, the previous year 620, and I understand a similar rate in Queensland. There is evidence from New South Wales, and I'd be interested in your own anecdotal evidence from here, that where advocacy or representation is routine, there's a much higher rate of rejection by the tribunal of applications to use ECT. And a Victoria Legal Aid representative was quoted as saying, if you're represented by a lawyer, there's a 50% chance the tribunal will grant the application, you'll have to have ECT, whereas if you're not, it'll be 90%. Right, we have some ongoing complexities in Victoria about the interaction between our own mental health legislation and our general medical treatment laws. There's some complexities here. I just want to point to these complexities. Most mental health treatments are in the form of a pharmaceutical, a pill. Our new legislation on medical treatment broadens the definition of medical treatment to include pharmaceuticals. This substantially broadens out the requirement for substitute consent for the provision of mental health. So what this means is in Victoria, from 12th of March next year, we'll have this situation where, so if you're a compulsory patient under the Mental Health Act, if you're not a compulsory patient, but you're not able to consent to your own mental health treatment, there'll be a new requirement for someone else to consent on your behalf. That is a big practice change that will be occurring in Victoria. So we're unclear what this will mean for guardianship and for the mental health system, but we are attempting to enliven our mental health colleagues about, and the community in general, about this big change that is coming. We ourselves have made the position as guardian of last resort. We'll decide on a case-by-case basis whether I'm likely to consent to mental health treatment for someone who's a non-compulsory patient who can't consent on their own behalf. If the person's actively objecting, we will decide on a case-by-case basis, but we are likely to take that view. We don't want guardianship, for instance, to be used as an alternative mechanism to the compulsory provisions of the mental health legislation. I'm sorry, that's a very complex point, but it's something that's kind of energising us at the moment. On the topic of advocacy, in Victoria, and I know you have statutory or advocacy that is provided under your legislation. In Victoria, we've got advocacy provided by the Independent Mental Health Advocacy Service, which is a part of Victoria Legal Aid. There's always some concern about how people would view that relationship between what is a legal body and mental health advocacy, which is not legal representation. Nonetheless, that seems to have gone on all right so far in Victoria. They provided just under 10,000 services to people on compulsory orders through this advocacy service in the year to mid-2016, and there are advocates in Melbourne and in regional areas of Geelong, Bendigo, Dandenong, and across the state. Also wanted to talk about just a quick snapshot of some systemic advocacy work that we did that has been mirrored up here by the Queensland Public Advocates Office in years gone by around long-stay mental health patients. We focused on, this goes back a few years, we've updated this research since then, but we did a project drawing on our volunteer community visitors. We established some criteria by which we said people would be a long-stay patient, so more than 3 months in the acute unit, 2 years in community care unit. And we asked our community visitors to identify how many people in the state were long-stay mental health patients. We found there were 99 people. The interesting point to make here was, back then we identified that 75 of those 99 people were in mental health facilities, not because they needed to be there to receive mental health treatment, but because there was no alternative accommodation available for them. So I know that's something that's replicated through other jurisdictions. All right, I'm starting to wind up because I've got about 4 or 5 minutes. So I want to just point to some challenges and possible reform before we lead into our next speaker. Okay, some practice questions, and I know many of these will be familiar to you. Do we overuse community treatment orders? We're high users of community treatment orders in Victoria, both in terms of Australia and international. Do we overuse community treatment orders? Is tribunal oversight of compulsory treatment timely and meaningful? In Victoria, there's a 28-day requirement for tribunal authorisation. One issue flagged by our Law Reform Commission years ago was, should that be 7 days? 28 days too long. Is tribunal oversight meaningful? I've told you before we had 588 orders for ECT. The tribunal refused 100 applications for ECT. How can people be better supported to make their own treatment decisions? Be interested in practice observations later on. Use of tracking devices. I know this has come up in Queensland in particular. It was raised with me by a PhD student the other day. I have my view about this. Talk to me about the situation in Queensland. Criminal justice system. I haven't even touched on the criminal justice system, but of course we know there's a whole other topic around unfitness to plead and mental impairment defences and their consistency with human rights standards. Mainly people with mental health and subject to those provisions, can be people with cognitive impairments as well. We've had some startling examples of kind of outrageous breaches of human rights under those headings, where, for instance, people have been held in adult prison despite never being convicted of a crime. We've had 30 people roughly in Australia in that situation, mainly in WA and the Northern Territory. There's some research that Piers Gooding and colleagues at Melbourne University have started to publish. There's a report recently released which talks about our need to better support people to take part in criminal justice proceedings rather than be deemed unfit to plead or not guilty by reason of mental impairment. As I say, that's on the topic. Related topic, but different, is the adequacy of mental health support services for people in prison. Prisoners are overrepresented when compared to the general community when it comes to mental health. We've also got the issue of a shortage of forensic beds, so acutely people who are in prison having been convicted aren't able to be moved to Victoria to forensic settings despite needing to be moved. All right, this again, I said unfitness to plead is a topic in and of itself, so is the NDIS. I'm just going to put the headlines here because I know that we can spend all afternoon on just the NDIS. Of course, there's the issue about how does the mental health recovery framework sit with the NDIS, which largely applies to 400,000 people rather than the 60,000 mental health people with mental ill health will be participants. 400,000 won't have mental ill health. How does the recovery framework for mental health sit with the NDIS? The issue of consumer eligibility, the case of episodic mental ill health, what constitutes substantially reduced functional capacity, what are reasonable and necessary supports in that context. I know we and many people are interested with those questions. There's great service sector uncertainty. I was at a meeting last week at the peak group for community mental health providers. They're worrying about what economists call thin markets and market failure, but the atomisation of services and the inability of service providers to provide whole person services, they provide particular services under the NDIS model, that's a concern. There's workforce challenges that flow on from that. And the interaction with other support and service systems, particularly with the mainstream services like health, acute mental health, criminal justice. When you get NDIS funded support, if you've got mental ill health and you're in prison, when does that begin? How does that help you transition to prison? Homelessness, of course, is another big area for mental ill health. All right, when it comes to possible law reform, should there be a legislated right to advocacy? These are just some things I'm going to throw out to you now to end the talk. Should there be a legislated right to advocacy? You've solved this so far as the Queensland legislation goes, but in Victoria, this is a big issue. Should incapacity be a criterion for compulsory treatment? Not a criterion for many jurisdictions in Australia. It is in Queensland, South Australia and Tasmania. Tasmania, curiously enough, is not a criterion for detention. You could technically be detained in Tasmania, have capacity to consent to treatment and refuse treatment, so you could be detained and not treated in Tasmania, which would be, again, an outrageous problem. Should we take steps towards the fusion of mental health and other substitute decision-making rules? Now, Victoria's Law Reform Commission looked at this some years ago. It said fusion of guardianship and mental health laws was a step too far at the moment. They were particularly worried about emergency treatment scenarios and the ability of guardianship laws to provide for emergency treatment. But one way in which they recommended a step be taken was to separate risk to self from risk to others. And they made the argument that risk to self should justify or should require a higher burden before you encroach on someone's freedom than does or should risk to others. So how do we promote and enable supportive decision making? Should we require substituted judgment even for compulsory mental health treatment? Should the authorised psychiatrist be required to resist to fraud, required to make decisions that the person themselves would have made were they able? Is that too fraud? How do we enable, or should we enable personally appointed substitute decision makers to make treatment decisions in compulsory settings where the risk is to the person's self, not to other people? So could I empower someone to, through a general power of attorney or a similar instrument, to make decisions that would apply in mental health compulsory settings where the risk I present is only to myself? That's something that the Victorian Law Reform Commission did propose, hasn't been done. Similarly, should we enable people to make binding advance statements, again, where the risk is just to themselves? Those are just some ideas that I'm going to throw out to you. I'm going to end there, and I look forward to hearing our other presenters and to hearing your questions and comments. Thank you.
Thank you very much, John. Again, panel members, I'm just going to speak briefly from their perspective. And just before I introduce our Mental Health Commissioner, just to give some perspective from Queensland, the less restrictive way that they've just had up there about as options to use of treatment authority, that's health directive, personal guardian, dream power of attorney, statutory health attorney, and then, you know, is that a mirror or similar to health decision making in relation to guardianship administration? That's health directive, guardian and dream power of attorney, and statutory health attorney, which is, you know, some shadows there in relation to the fusion discussion. So that's just a backdrop. But more importantly, I'd like to welcome and introduce Ivan Frakovic as the Queensland Mental Health Commissioner, and is going to bring us some perspectives for you this afternoon. Thank you.
Thank you very much, and certainly not a topic of great detailed knowledge for me around the Mental Health Act, but certainly from a Queensland Mental Health Commission perspective, we will certainly have a strong focus around, I suppose, the human rights protection of this particular new legislation. And there's people in the room here, John's here, chief psychiatrist, and people from the branch and others. There he's standing in the corner, he's watching everything I say, because he knows that act backwards actually speaks with the act. From a Queensland Mental Health Commission perspective, I think we provided a submission input into the new legislation. I have to say I wasn't in the position then, but I have been advised that most of the suggestions that we have made and consulted broadly around the suggestions we made have been actually taken up. But I think in terms of a consumer perspective, as I think, you know, I was trying to sort of point out some of the key elements that have changed in the Act from the previous Act to this Act. I mean, that whole concept, and I think the key concept about that least restrictive way of treatment has been strengthened overall. I still think it needs work, but I think at this stage the concept is starting to actually get more traction And I think there are some challenges with how you strengthen that, so I'm not saying it's easy, but I think the intent and the focus of it is starting to go into the right direction, at least what we're hearing from a consumer, carer, family perspective. If you look at the new legislation, and I'll just go through some of this quickly now, then I'll put up some slides, not that I want to spend hours talking sort of to the slides. The new Act in terms of consumer rights and protecting consumer rights has strengthened a range of things which were probably not as well articulated in the last Act. And to me around is that, going back to your point, John, around that capacity definition, and whether you can do that adequately enough in legislation or what are the challenges with it. But I think Queensland has grappled with that in terms of providing a definition. I'm sure there'll be other ladies here in the room and others who will make comments about the adequacy of that. But I think, again, it's been strengthened from what I do recall, having a bit more knowledge of the previous Act than I do of the current Act. And not that it's changed a great deal, but I think that sort of definition, as you can see up there, gives us a bit more insight around, you know, understanding how people have, you know, do they have the capacity to make that right decision. The other elements, and you don't need to go to this slide, but the other elements really go about, you know, making sure, again, this has been strengthened, making sure that the patients, or the consumer, understands the information being provided. I think there's a much stronger focus on that element. Now, again, we don't know in practice how well that's working. It's only, how long, John? Not even 12 months since we've had this new legislation? About 12 months. So we're very new, sorry? March this year, so we don't even have, you know, sort of 12 months of information. So you know, we don't have a lot of feedback. We do, to some degree. We hear from the sector and ladies in the front here and a whole range of places. So I think we need to keep all that at the forefront to see how that's working. What I do like is also about, and we certainly pushed for this in the sort of feedback that we provide, was really around the safeguards around seclusion and increasing those. And I think there has been a strengthening of that. And I think, John, in your report that we saw, and I think they got some media play, we need to think about, you know, how we actually, you know, secluding people and what's the right level and how we can actually reduce that further, etc. But I think the safeguards around the seclusion certainly seem to be making more sense, at least from where we sit. The new initiative, John, I wasn't sure, this John here, around how it applies to some of the stuff you spoke about in Victoria, about the appointment of the independent patient rights advisors. Now, I'm not sure how that equates to what you talked about. I couldn't quite see where it sits. A bit different. And the other, John, I haven't seen this in other legislation anywhere else as well. So is this quite new for Queensland? That's my understanding of it. I haven't seen it anywhere else. But again, what's interesting in this and what we're going to be looking at, there is a challenge with some of these things. Before coming into this job, I was in sort of with an organisation that actually got allocated 10 of these patient rights advisors. 5 in the north, Metro North, and 5 in Metro South. We were an NGO employment, which gave you a sense of maybe greater independence. I think the question that's being asked in Queensland at the moment is, if they're appointed by the HHS, can they, and how can they be independent? And I think we'll have to look at that, and look at the 2 different models operating in Queensland and see whether that really does make a difference, depending who they're employed by and how independent you can be. I also saw that there was going to be a strengthening of the statement of rights, so people are really aware, and both staff but also families and carers are really aware of, you know, what their rights are, which I think is good. And we've also expanded, we can nominate now 1 to 2 people as sort of nominated support people, which we didn't have in the last legislation. We've also got now we had elements of this, John, from my recollection. I was working with the previous Act around the Advanced Health Directive. We had elements of that in the previous Act, but I think that's been strengthened much more in this particular Act. It's very, I suppose, articulate at the moment around what that means and how people can exercise that. And then I think this is quite an interesting one, but it sort of came through again, was that sort of rights in terms of communication when you're an inpatient, and that people will be able to now use their mobile phones and sort of and electronic devices, which I thought was interesting that we've actually started to open up some of that. So they're the major elements that I picked up out of the changes from the previous Act, what's been sort of strengthened in this particular Act. Now I'm sure there's people in the room here who may be able to correct me if we haven't picked up exactly all of the sort of issues. Now, if you just go through that, I think I've spoken about, sorry, just the second one, the Advanced Health Directive. I think it's an opportunity again for people to be able to, as it says there, to be able to, make those decisions about how they want to be treated, but potentially they're not able to make that decision. So I think that's a useful way. It's quite articulate now in the legislation. Next slide, please. I've spoken around this stuff around communication, and I think again it's important that the information being provided to consumers now is probably greater than it was in the last legislation. And then around the patient's rights advisors and generally the patient's rights. From a mental health commission perspective, we're interested, and even though it's been 6 months, and we really don't have a lot of early indications. We have some, but we don't have a critical mass to be able to make some decisions around how things are going. I know that Queensland Health is doing their own evaluation of this legislation, but the Queensland Mental Health Commission is also doing an evaluation. We're taking a sort of how is the Act protecting people's human rights? So we're taking a bit of a slightly different perspective apart from what Queensland Health will do in terms of the mechanisms of the Act. So that will include, we will look at, as part of our own evaluation, which we will get people externally to do this for the Commission, is the role of independent patient rights advisors. We're going to look at that, particularly the sort of comment I made earlier, the operation of the Mental Health Review Tribunal. But this is all in the context of protecting people's human rights. The Advanced Health Directive, that sort of rights and information that we give to people and community visitors and a whole range of things in that, is that supporting people's human rights? That rights to information. And what we want to do is try and finish this by potentially at the end of next year, early the year after, to give us at least 12 months, 2 years of information to be able to see how things are actually going. And then finally, we want to use that to compare how things are happening in other jurisdictions. John spoke about Victoria, what's happening in Tasmania and other jurisdictions. We want also, whether these processes are really working from a consumer care or family perspective in terms of their own rights, particularly the human rights. So that's probably all I want to say for where we're sort of coming from as a commission, but I know that John Riley, the chief psychiatrist, and there's other people here from the branch who can tell you exactly the details of what's in the legislation. So thank you.
Thank you very much, Ivan. I'd like to introduce Natalie Siegel-Brown, the Public Guardian, to bring her perspective to the new Act and to sort of check in relation to, from her perspective. Thanks very much, Natalie.
Thanks a lot, Karen. I must apologise, I don't have any pretty colourful slides. I do have a lot of illegible scrawl, which is kind of how I get by, so I will try to decipher it. I want to first acknowledge the traditional owners of the land on which we're meeting, the Turrbal people, and pay my respects to their elders past, present and emerging. And also recognise that Aboriginal people are very much front and centre of our thinking in this legislation, because we know that a very high proportion of people suffering from mental illness and in some of our authorised mental health services are Aboriginal people. And when we're thinking about all of this, we also need to think about the cultural context and cultural component around their support, which may not be the same for other people. Many of you in this room, I recognise and will know a lot about what the Office of the Public Guardian does, and as John pointed out, Mary's function as a systemic advocate in Queensland is different and separate to my function as an individual substitute decision maker in the guardianship space. But some people may not realise there's quite a diversity in the function what I do. So Queensland's very different in that the Office of the Public Guardian means that I am both the children's guardian and the adult guardian. Now, those two functions are not unified in other states and territories, but what it means is I get a very unique overview of the issues for kids and adults in this state. So very briefly, I have a role as an oversight body, and I also have a role as a substitute decision maker of last resort. I have community visitors who are really monitoring and advocacy for all children and young people in care. We also advocate for kids who are in the child protection system, even though they may not receive a community visitor per se. They are entitled to the advocacy of my office. I visit and advocate kids in youth detention and those in disability funded facilities, but I also visit and advocate for every child in an authorised mental health service. And the new Act has been quite fantastic in the information that it has provided my office. So the new Act requires that my office actually receives information every single month on the restrictive practices that are being used against children and young people in authorised mental health services. And that has shone a light on a great deal of things. We also receive information now about children and young people subject to ECT. So that really informs our advocacy a lot better, and that's a whole path that I could go down, and I won't today. In respect of adults, I have both an oversight function and a decision-making function. So I provide community visitors to all authorised mental health services, disability-funded services, Level 3 hostels, and in fact the number of sites that I visit is ever expanding under the NDIS. And that gives me a really unique purview about common issues that are facing people with disability and mental health, and probably most pointedly, and I'll get to this in a moment, those who have a dual diagnosis. So those who are diagnosed with mental illness and have an intellectual disability, who I really see as probably the most vulnerable in the whole concept of the least restrictive way, due to probably what would be regarded as both service and system failures across the mental health and disability service system continuum. There's nothing there, and the default becomes something that is very far from the least restrictive way. I'll get to that in a moment. And John's very clearly and beautifully articulated the concepts of guardianship earlier. So for adults, I'm also a guardian of last resort. What does that mean? It means that when QCAT, and it is QCAT, who has made a decision or a declaration that somebody has impaired decision-making capacity, and there is no other person in that person's life who would appropriately be appointed as their substitute decision maker, then it comes to me as the public guardian. I'm also a statutory health attorney of last resort for every single Queenslander, and in fact everybody who comes to Queensland and finds themselves in hospitals and their loved ones can't be located if they don't have decision-making capacity or any form of cognition. So for example, last week I was on call leave, and our executives constantly on call. If somebody finds themselves in a hospital and they are in an unconscious state and nobody else can be located for them, we get a call, and we're the people who will make the decisions about provision of healthcare and withholding and withdrawal of life-sustaining measures. My office also has a function to investigate allegations of abuse, exploitation and neglect against any adult with impaired decision-making capacity, and a very high proportion of those are instances of elder abuse. So I was just looking, and I think we opened about 270 cases of that just this year alone, and we probably got about a 27% increase on last year, and we're exercising some fairly serious functions in that domain, including I execute warrants to remove people where there's been instances of elder abuse. So a very diverse function, certainly keeps me off the street. I do love what I do. So I feel fortunate in the sense that I obtain a perspective on the least restrictive way and the way the new Mental Health Act is working, both from my function as an oversight body and my function as a guardian. The concepts of supported decision making are really what I consider to be the lighthouse of my organisation, and John's talked a little bit about those and how they really are human rights that are underpinned by the UN Convention on the Rights of People with Disability. The Guardianship and Administration Act in Queensland, and while it has some problems, as do all pieces of legislation, is actually a fairly light piece of legislation, and it has some general principles articulated in Schedule 1 which really support this concept of supported decision making. And there are some changes going through to the Guardianship and Administration Act which really put the UN Convention on the Rights of People with Disability and the human rights of people under guardianship at the forefront of that act. So the changes that are going through at the moment, I think, actually look to fundamentally increase the focus on the human rights of people under guardianship. So we've been working our tushes off at the Office of the Public Guardian to make sure that all our practice directions, our processes, our approaches really reflect that concept of supported decision making. But I did want to talk to you a little bit about the way the Mental Health Act works, and something that some people think is a little bit controversial in respect of this concept of less restrictive way under the Act. And I think John alluded to it at the end of his presentation. And you just saw before the hierarchy of decision makers in respect of the Mental Health Act. So where a person has the ability to make their own decisions and have their views and preferences followed, even if it's not at the time at which psychiatric care needs to be provided, obviously they've got the opportunity to express that one preference through an enhanced health directive. But where, under the less restrictive way, where the decision maker is a guardian, and somebody is declared to have that impaired decision-making capacity, our office would argue, and we certainly argued this through the formation of the legislation, that this is as restrictive and perhaps even more restrictive than a doctor making a decision under a treatment authority or the administration of a treatment authority. So what has to be remembered is that it's QCAT who appoints the guardian. It's not the person. And the guardian's role under the Guardianship and Administration Act is to be the substituted decision maker, and in both circumstances, you've still got somebody else who's making that decision on behalf of the person. But the safeguards that sit over the doctor making the decision as opposed to the guardian are actually far stronger. So this is why I say having a guardian make a decision around mental health treatment or the use of force in the administration of treatment is actually more restrictive than the requirements that sit around a doctor. And the reason being that there's actually a lot more checks and balances that sit over the doctor. So, for example, somebody placed under a treatment authority would be subject to a review after 28 days and then ongoing 6-monthly reviews by the Mental Health Review Tribunal. Whereas a guardian can actually be appointed for anywhere up to 5 years. There's no review of a guardian's decision unless the person themselves has to initiate it via some mechanism such as a separate representative, and even that requires some level of self-efficacy and self-advocacy. And the Act only requires a guardian to visit a person, or the public guardian to visit a person once every 12 months. I'd like to say that we get out every week to visit all our clients, and we're certainly getting out to all of our clients in forensic facilities that often now, we're getting used to. But realistically, there's nothing that reviews the decision of that guardian for that person. And at the Office of the Public Guardian, obviously, I have a level of consistency, I have practice directions, and my delegates are subject to my review. I'm subject to Mary's review as well, which is a fantastic thing. But private guardians have a lot less rigour surrounding them, so they don't have any practice directions to follow. They may not have the ability to, or the fortitude to question particular decisions of psychiatrists, whereas in my space, I think if you spoke to some psychiatrists in the public system and you mentioned my name, their eyes would roll to the back of their heads because they're so sick of being asked questions by me. So even the distinction between public and private guardianship has, I think, depending on the person, some distinctions around the oversight. So I think that's always something to remember. What I find really interesting is that since, and we do have a decision-making framework and a mental health treatment consent policy on our website if you're interested in having a look, and I do apologise, the website is an absolute maze to navigate. If you find it, you deserve a trophy. I'm working on that bit. Despite there being this capacity for the public guardian to make decisions around mental health treatment and to make decisions around the use of force in the administration of that treatment. I checked the records last night, and since the 5th of March, which is when the Act was commenced, I've not had one valid request for consent to treatment. So I find that really interesting. Perhaps the message is getting out there that it is actually better to go down the road of a treatment authority because it's subject to more checks and balances. Maybe it's an issue of convenience. I actually can't explain that. I mean, we're only, 7 odd months down the track now, but it's certainly something I do intend to interrogate further at some point when we have a fair bit more data to go on. I guess I wanted to make one last comment about how we manage this concept of the least restrictive way in practice for our dual diagnosis clients. The issue of indefinite detention, particularly for dual diagnosis clients, has been an issue that's been explored very well by Bernadette McSherry, which is a professor who actually taught me law back in the old Monash days, now at Melbourne University. I think, John, you mentioned some of her research in your presentation. The name of the mini-series that was on Foxtel, is it Netflix, Making a Murder? Which really is a series that's based on this very same concept, was kind of the intro that Bernadette McSherry gives to the same sort of issues here in Australia. I really encourage you to have a look at it. I think it has very specific context here in Australia, because when I think about some of my clients that I have in high security units, particularly those on forensic orders who are dual diagnosis, so those who have been diagnosed with mental illness and intellectual disability, because the disability service system continuum and even the mental health service system continuum outside of that facility may not have all the relevant step-down services in place, I often feel that I'm witnessing the MHRT being almost, or feeling like they've got no alternative but to continue someone's forensic order in detention in a service, as opposed to looking at their transition out to the community. And I constantly feel like I'm hearing mental health saying, disability, you guys need to step up now. This is a disability client. His mental health is under control. You now need to step up with the right disability supports. And I hear disability say, no, we've done our assessment. We believe the prevailing condition is the mental illness, and there ends up being this, well, possession of 9/10 of the law is in your facility and therefore he stays there. So the ability for the Mental Health Review Tribunal to make the decisions which might be considered less restrictive are often really constrained by the service system that sits outside, and those are the decision makers around disability assessment and also funded service provision and allocation of funds. Will the NDIS change that? There are those who say it'll make it worse. There are those who say it will make it better. I can honestly tell you that amongst my client group, I've seen instances of both. I've actually more seen instances where the NDIS has come to the party, whereas previously we were really concerned that, particularly for forensic clients, there would be no package available to them and they wouldn't be able to move into a step down into the community. The fact is we still have, as John referred to, thin markets and market failure with respect to the disability service continuum, particularly at the acute end. The service system under the NDIS, the disability service system, has not grown to meet the market and to meet the levels of acuity that are currently completely uncatered for outside of the authorised mental health service system for people who are dual diagnosis. 1 minute? Perfect. So I dream that the market will come to meet it. It hasn't been realised yet. It may well do so, but the trickier end of the system is always going to be one where there may not be quite the appetite to enter the market, even though these clients attract a higher funding package. So, whereas perhaps 6 months ago I would have come to you and said it might be all doom and gloom and that things will get better under the NDIS for dual diagnosis clients who are on treatment authorities and the like. I think the jury's out. I look forward to hopefully coming before you again in maybe 6 months, a year, and telling you that story.
Okay, thank you. I'd like to welcome our next panel member, Mary Burgess, who's public advocate, part of the dual team that we have here at Council. Thank you very much, Mary.
Thanks, Karen. Before I commence, I'd also like to acknowledge the traditional owners of the land on which we meet today, the Jagera and Turrbal peoples and their elders, both past, present and emerging. And thanks to ADA Australia for organising this forum today and assembling with some panel of people who I hope will give you some thought-provoking discussion and answer hopefully some of your questions about the Mental Health Act. A lot of people have told you about what I do. I do have some things. I'll give you a really quick rundown. I do systemic advocacy, as you've heard about 3 or 4 times, to protect the rights and interests of people with impaired decision-making capacity. And my position is an independent appointment under the Guardianship and Administration Act. So now they've got me, they're stuck with me for at least as long as they appointed me. And the issues that I'm expected to focus my systemic advocacy on are promoting and protecting the rights of adults with impaired capacity, protecting them from neglect, exploitation or abuse, encouraging the development of programs to help them to reach the greatest degree of autonomy, and promoting the provision of services and facilities for them, and monitoring and reviewing the delivery of those services and facilities. And so systems advocacy, I'm probably telling people who know this already, but it's about focusing on the systems that impact on people and trying to advocate to influence change. And we do that by making submissions about new laws and government reforms. We try to get the government to prioritise when they're doing plans or approaching new policies to prioritise the interests of people with impaired decision-making capacity. Or we also try to influence the way they deliver services and make sure that they're more responsive and inclusive of people with impaired capacity and their supporters. And I also have some other powers that go with my responsibilities. I can intervene in any proceeding in a court or tribunal or an official inquiry that involves the protection of the rights of people with impaired decision-making capacity. And I have a right to all information necessary to monitor and review the delivery of services and facilities to those people. So that's actually a very wide information gathering power, a lot like an ombudsman's powers. And finally, I can make reports to the Parliament about systemic matters that impact people with impaired capacity. And that's a very sort of powerful, it's a powerful opportunity to ensure that information about what's happening to people with impaired capacity is getting to our lawmakers, but also getting into the public domain, and isn't getting edited and on the way. It goes out, you know, as it's written in the standard. So to today's forum. Now, I'm going to be taking a much broader sort of broad brush look at the Mental Health Act because mine is a systemic approach. And I thought I'd look at what I think are some of the really positive aspects of the new legislation, and then also look at some of the things that I think are negatives or some challenges that we're going to have to tackle. And some of them really intersect with the sorts of issues that you've raised, John, already. So the first is that the first positive is the really strong focus of the Act on achieving the least restrictive way for people and focusing on their rights and liberties of the people who are impacted by the mental health factor being dealt with under it. And I think that that's really important, and there's a really good, clear, strong statement of principles at the front of the legislation that is really important. It sort of sets the tone for the Act, and it forms an educative kind of function for those who are working with it, and I think that's a really positive thing. And of course they're based on a human rights framework, and that of course is fundamental to the issues that I'm concerned with for people. So I see that as a great positive. The second very significant and positive impact of the Act has been the funding of legal representation in the Mental Health Review Tribunal. And in the more than 16 years that the Tribunal has been operating until the commencement of the new Act in March, there was no funding for representation for patients, and that's despite there's 20,000 hearings per year in that jurisdiction, and only a very small proportion of people who were hearing in them in that jurisdiction until recently were getting any legal representation, and that was really only happening courtesy of organisations like QAI and QPILCH and occasionally ADA, and they're all very overstretched and underfunded, and also the ASLs who have, as Natalie pointed out, we've got a high proportion of Aboriginal people in our mental health system, and they play a role in that as well. And very occasionally, people will have family with the means to pay a private lawyer, and you're pretty lucky if that's something to do in that system. So essentially, the Mental Health Review Tribunal operated as a closed shop, a very closed sort of legal forum for years, and I don't think that is a good thing for for that forum. I don't think it's good for any system. And now, having had some time to observe the operation of the Mental Health Review Tribunal, I can see that there are arguments that people might think it's easier to run a tribunal without lawyers, because they get in there and they complain, they haven't got material, they ask for adjournments, and they start needling people, asking awkward questions. And life's a lot easier if you can just chat it through. But I form the view that if you want a really good legal system, and a system that really where everything's in the sort of balance it should be in, you need to have all of the players in the room doing their job and creating that tension that keeps each other honest and challenges each other and the things that they are putting forward. So and having, when everyone's there and they're all acting conscientiously,